Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. Technology has always moved fast, but the current climate feels unprecedented. AI tools are rapidly evolving, and the pace of change makes it hard for employers to stay compliant while exploring new opportunities. It also means that the law and regulations governing technology are always in flux. This week, we're taking a look at the latest. First up, a federal judge found in United States v. Heppner that conversations with an AI tool are not privileged. This could have nationwide implications for parties concerned with keeping information secure during government investigations and litigation disputes. The ruling focused on the defendant's use of the AI tool Claude to discuss documents and legal issues in the case. The court found that the AI conversations and work product were not privileged, even though the defendant later discussed them with his attorney, due to Claude's terms of service and privacy policy. This is a case of first impression in a criminal matter. Still, it serves as a stark reminder that the conversations with a public AI tool about an active case or any other employment matter are likely not privileged. A recent DOJ enforcement action is a reminder that you also cannot assume your AI is following the law, particularly when it comes to hiring. An IT company was assessed nearly $10,000 in fines after the Department of Justice found that the job postings generated by AI for the company excluded U.S. citizens. This clear violation of the Immigration and Nationality Act likely would have been caught by a human hiring process. Keeping a human in the loop is critical with all AI processes, but the real caution here is to look deeper. Modern AI work often involves agents which can handle multi-step processes on their own. Employers must have an AI governance framework in place to ensure that AI does not make unsupervised employment decisions. Washington employers banned from chipping employees. Starting in mid-June, Washington state will prohibit mandatory microchip implants for employees. More than a dozen states have banned the practice, which is used by some companies on a voluntary basis for identification and payment purposes. These mostly preemptive bans serve as a barrier to potential privacy violations and are a good indication that states are viewing this space with suspicion. We close today with a great example of the speed at which this space is moving. Colorado's first-of-its-kind comprehensive AI law could be sunsetting before even taking effect. A working group has released a framework to repeal and replace the 2024 law, which would place onerous compliance and reporting obligations on all employers, including small businesses. The new proposal would remove these strict requirements for employers. That's it for this week. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.